Good morning, Mr. Salas. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and/or 2.
Right off the bat, the judge hits Mr. Sales with the reality check. 2 charges, both carrying potential jail time. But pay attention here. The next few seconds will reveal whether the evidence even supports those charges. Watch how quickly this turns into a legal tug-of-war over what counts as driving in a DWI case.
$1,000 fine. You're also charged with evading arrest or detention. On that, you're facing up to a year in jail and/or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
On or about March 26, 2025, an officer was on patrol on Gulf Freeway in Harris County, Texas. The officer observed a motor vehicle disabled in the left hand with grass speeding, dividing southbound and northbound lanes of traffic. The motor vehicle had multiple airbags deployed and all 4 tires appeared to be damaged. On arrival, the officer observed additional motor vehicle disabled on the open access roadway of what was formerly a car dealership. The officer observed the witness walking towards the officer, trying to get the officer's attention. The witness said 5 minutes prior to the officer's arrival, the defendant approached the witness after the witness' tires were blown out. The witness informed the officer that the defendant demanded to use the witness's phone. The witness advised the officer that the defendant wanted to contact the defendant's mother to pick up the defendant from the scene. The witness told the officer that the defendant continued to approach aggressively and that the witness told the defendant the witness would call the police if the defendant did not stop. The witness said the defendant fled the scene on foot. The witness described the defendant's clothing, and the officer observed the individual matching the description running and approaching the scene of the incident. As the defendant approached the scene of the accident, the defendant began walking in a parking lot adjacent to the freeway. The officer gave loud verbal commands for the defendant to stop. The defendant fled on foot on the grass along a ditch. The defendant slid down a ditch and the defendant crossed the Water Creek, then climbed the fence attached to private residence, and fled on foot for approximately 0.4 miles before he was later detained by a Houston Police Department and turned over to deputies. The scene was moved to a Shell station to continue the investigation. The officers contacted the defendant. The officers observed a strong odor of alcoholic beverage emitting from the defendant, and the officers observed the defendant have red glossy eyes, slurred speech, dry mouth, repeating phrases, and agitated demeanor.
You say a shaky demeanor?
Sorry, agitated demeanor. And the defendant denied drinking alcohol and initially denied drug use, and then stated that he had been off for a couple of days and had consumed paste or coke. The officer, through training experience, noticed to be representing cocaine. The defendant admitted that he was going to a girl's house when the incident occurred and agreed to perform the standardized field sobriety tests. Those were administered, and the officer observed success exclusion on the HGN. The officer did not administer the walking tour of the one-leg stand due to the defendant injuring his feet while fleeing.
Okay, pause. Here comes the moment every legal nerd waits for. The defense attorney challenges the entire foundation of the case. They're basically saying, where's the proof he was actually driving? If the state can't tie the defendant to the driver's seat, even a messy accident scene and intoxication signs might not be enough. Listen closely. This is where probable cause can live or die.
Considered to a breast sample, which was not completed due to interference being detected. The officer obtained a search warrant for the defendant's blood, and there was a blood draw for the defendant.
Okay. Your Honor, may I come?
Please.
I might have missed something, but besides the state saying that my client said he was going to someone's house, I didn't hear any operation facts.
I mean, he admits driving. He's by the car when the officers get there, right? Is he by the car when the officers get there, or where is he?
From what I have, Your Honor, he has fled the scene when the officers get there, and then comes back to the scene.
Okay.
To the officers. The witness.
Does the witness put him operating at all?
Yeah, just one moment, Your Honor.
Take your time.
Yeah, all I heard is going somewhere. It doesn't say he was driving anywhere.
So you see, the DWI, they might refollow, but might have been the wrong corner. Sometimes they fade in, it's getting to go.
I'm not sure, Your Honor, there was anything additional. This is kind of like this mirror guy.
Hey, look at
Good to
it.
see you again, Your Honor.
Yeah, what's up, man? Good to see you. Do you have anything else?
Your Honor, it does look like the witness stated that he stopped and exited his vehicle and observed the driver of the RAV4. That's what I have, but
So it doesn't match up with my client.
Tires were blown out. Martinez stated once he stopped and exited the vehicle, he observed the driver of the RAV4, identified as Abraham Elias Salas, using driver's license, come out from the grass near the RAV4 and aggressively approach him, requesting to use his cell phone. Stated that he was trying to use his cell phone to call his mother to come pick him up, and that Salas said the RAV4 belonged to his mother. Martinez stated after a short time that Salas asked Martinez if he had papers for immigration.
Judge, even with these facts, it doesn't show driving. Even if he owned the car, we have no idea when. There's no facts to say that he was driving the car, that he admitted to driving the car. I don't see operation still.
So Salas stated that he was driving the RAV4 because he was going to a female's house and continued to speak. Salas then stated that he ended up in the grass because he was scared. Then stated that he was a Mexican driver that swerved in front of him and allegedly
He said a Mexican driver swerved in front of him. Is that what he said?
told him no Tango Papeles or I don't have papers. Salas said the other driver was in a gray Toyota telling him to go away. Stated that the RAV4 and the alleged Toyota came into contact, causing a collision. Salas stated that he was coming from his house in Friendswood, but denied having anything to drink. So
Yeah, I mean, I think if they,
he was operating the vehicle at the time of the accident.
and you have the other person say something, right?
they
That's
say
all.
that it was, they identified him as the driver.
And here it is, the turning point. The judge officially rules there's no probable cause. This doesn't mean the defendant is innocent. It means the evidence simply isn't strong enough today. But notice the judge's tone. He's practically giving a life lecture from the bench. Question for you guys. Do you think judges should use moments like this to educate defendants? Or should they stay strictly procedural?
Just never say they saw him driving or operating the vehicle.
So I believe that they believe, based on the circumstance, that it was a driver. I don't know if the witness actually saw him driving. What we have to prove the driving facts is that Reeves fired to believe prior to his arrest. He admits that he was driving the vehicle at the time of the accident, and the vehicle was found at the scene of an accident. It was found nearby. Was observed coming out of the grass nearby. By the driver.
Although it's an admission, Judge, it needs to be an admission plus. I don't see that being enough for the plus.
Mr. Salas, I'm going to find that there's no probable cause in your case. Every freaking day in our county, someone dies from an alcohol-related collision. Don't become a statistic because of a boneheaded move that you make where you kill someone. Do you understand? Now, I'm going to find no probable cause. It's very possible they go indict this case at a later time if they get more evidence, but don't kill anyone. Do you understand?
Yes, Your Honor.
See,
Thank you, Your Honor. Are there any conditions you're imposing on the evading case?
no, I'm going to find no on both.
On both. Thank you, Judge.
Talk to me.
Desnick Smith. He's one of the ones that,
Yeah, ones, okay. What's the last name?
Smith, Desnick, did you do? Out of Louisiana, one of those four guys that you already talked about. He's the one that did not have he was a passenger, not the one with the weapon.
There were 3 passengers.
I talked to his mother.
How old is this kid?
He's awfully young. I can't, he's got a computer, I don't. He looks awfully young. I talked to his mother. His mother's willing to post bond and able to post bond if it's reasonable.
Therein lies the question. What is reasonable? Right.
1,500 would be reasonable.
He's coming back in.
I know. Nelson, did they respond?
What's that?
Did they respond on Nelson?
Smith, may bring up Mr. Smith.
Okay, yeah, we're on Smith.
Smith's coming out now.
Black claims that they told them they were not going to mess with it. We'll still wait for the official word from Florida. What's that name of that city?
I don't know that, I just went by the county.
It's another one of those.
I've been mispronouncing,
Natchitoches.
I've been mispronouncing
I
county.
know.
Morning, Mr. Smith. How's jail?
The worst experience of my life, bro.
Makes me really happy. It's supposed to be. You know, the idea of jails are that you learn. And unfortunately, we have people that just don't get it. No matter how long the sentences are, no matter how cold the bars get, they just don't get it. You're wanted out of Louisiana for this car.
Yes, sir.
Your lawyer's asking for me to set you a bond, but I don't know. I've never met you before. I don't know you. You know, one of the things that I consider is, number one, are you going to go back if we set you a bond? Number two, are you a dangerous person? Because I don't want to set you a bond and then you leave a wake of destruction on your way to Louisiana. I mean, I don't want that.
Yes, sir.
So, Mr. Kim, tell me about Mr. Smith.
Your Honor, this now defendant, along with 3 co-defendants, stole a vehicle out of Louisiana and transferred state lines on the same day and was apprehended in Harris County. He's facing a felony charge there due to the fact that they transferred state lines within 24 hours of stealing the vehicle, which was captured on surveillance video. State would be opposed to a bond as state considers him a flight risk.
Any prior criminal history?
No, Your Honor.
Judge, he is from Natchitoches, Louisiana, which is where the offense is from. His family lived there and he was born there. They moved to Manning, Louisiana. I talked to his wife and his girlfriend.
His wife?
Mother. That's what I-
23.
That's what I
His
call it.
mother and his girlfriend, okay? I spoke to his mother, Sophia Smith. She lives in Manning, Louisiana. She will post his bond. And I spoke to Sophia Smith and she'll come over and pick him up. That's and transport him back to Louisiana.
Here's the thing, Mr. Smith, is I need you to understand that we don't play games. If I set you a bond and you make that bond, we give you 2 weeks to go turn yourself in.
I will, sir. I promise.
We don't play games. So if you fail to do it, I'm going to revoke that bond. I'll set it at 0. I'm going to issue a nationwide warrant for your arrest. I'm going to get you because you can't run forever. And the next time you will not get another one. Do you understand? Okay. I'm going to set you a bond at $1,500. Here's the other thing. Life is short. Life, when you end up with a bunch of convictions, it doesn't become a fun life. What makes life fun is you get knowledge. When you get knowledge, you buy things because you get money. But you only do that when you go out there, school, learn, get a good job. That's what life is about. I'm not picking up convictions.
Sir, that's nothing. I'm in college right now too, sir. That's why it's kind of crazy. I'm
Really in college?
in audio arts.
And now with all this, really? Dude, when you hang with boneheads, it doesn't end up well, you know? Get a clue so you don't end up back here. Mr. Smith, I'm going to set your bond at $1,500. Just, Mr. Smith,
Yes, sir.
don't disappoint us, man. Do something with your life. Don't become another statistic. $1,500 and then do right, man. It's not hard in this life, you know? All right, we got you. buddy.
Thank you, Judge.
So if he can make it, I'll print out the reset for him to sign and I have the waiver withdrawal for you to sign. 'Cause he's-
I'll bring that. Don't send him back yet. You got some.
Yeah, so I'm typing up the reset right now, but the waiver withdrawal is there for you to sign.
You're Jeffrey Chauvin.
Yes, sir.
Mr. Chauvin, you're charged with criminal trespass. You're also charged with resisting arrest. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, sir. Okay, please.
On March 5th, 2025, an officer was dispatched to a trespasser call at a Whataburger in Harris County, Texas. Complaining witness, an employee, stated that she told the defendant who was in their dumpster in the parking lot to leave, and the defendant refused. Staff tried to tell the defendant to leave again at 1 a.m. and defendant stated that he would leave in an hour. At 2 a.m. and 3 a.m., defendant was still refusing to leave after being asked to do so multiple times. At 5 a.m., the trash company came. Defendant refused to come out so they could not pick up the trash. The officer observed defendant in the dumpster and asked him multiple times to come out and that he had been trespassed from the location, but defendant continued to refuse for about 30 minutes. The officer asked the defendant if he would be willing to go to the jail diversion center, and defendant said yes. The officer handcuffed the defendant so he could eat food. Officers provided him. The officer went to reapply handcuffs, but the defendant resisted passively by not following officer commands to lean forward. The defendant verbally stated, "No, I'm going to keep my hands here." After several attempts and the defendant not following verbal commands, the officers removed the defendant from the vehicle and put him on the ground so he would not hit his head. While officers attempted to handcuff the defendant actively resisted by pulling his arms away from officers. The officers still took defendant to the jail diversion center, but upon arrival, the defendant stated he did not want to be there and just wanted to be released, so he was rejected. While en route, the defendant had taken his seatbelt off and put his handcuffs in front of his body. The officers told the defendant he would have to be handcuffed behind his back, and the defendant agreed. Officers told the defendant to lean forward, and the defendant stated, "No, you're going to have to shoot me," and actively resisted by pushing his body onto the officers in an attempt to escape from the patrol vehicle. The defendant stated he would stop resisting once officers loosened up control, and when officers did, he would go back to actively resisting by attempting to get out. The officer was eventually able to secure the defendant. The defendant broke the officer's nail on the right hand, and officers sustained minor bruises to his finger and forearm.
Charged with the assault on a peace officer, Mr. Chauvin, I'm going to find that there's sufficient probable cause to go forward with the case. Do not go back to this Whataburger.
Yes, Your Honor.
Do not go back to this Whataburger. Do not pick up any new cases and show up to court. When you show up to court, good things happen. If you take off again, it's not going to go well. We've already given you, this is your second PR bond. Do you understand?
Yes, sir. I was not told I had court the first time. I was homeless. I was sleeping in a dumpster.
Okay, well,
when
I
woke
don't want
up-
you to say anything now because I don't want you to hurt yourself. Let me give you a lawyer. They'll be able to talk to the lawyer how to resolve this case. Just, we're going to give you a future court date, most probably. If you miss it again, I'm going to issue a warrant. You're not going to get a third PR bond. Do you understand?
I have to remain in Houston until this.
Well, let me get you a lawyer. We can talk and try to see how we go forward. For now, let me just have you go to Victoria, sign a reset. I'm going to have you take a seat in the jury box, and then we're going to get you a lawyer here momentarily. Okay? Please. Are you Alfredo Gutierrez?
Sure.
Mr. Gutierrez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. As you can see, your lawyer is here with you, not in person, but on Zoom, so that you're not here alone. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay. Please.
Right, just have one moment. I'm sorry, it's moving a little slow this morning.
Okay, no problem. Oh, I see. You're also charged with unlawful carrying of a weapon. On that case, you're facing up to a year in jail and or a $4,000 fine. Okay.
March 25th, 2025, in Harris County, Texas, a law enforcement officer responded to a single vehicle accident and made contact with the defendant, who stated that he was just being stupid and spun out and hit a pole. The law enforcement officer observed the defendant to have bloodshot eyes and a mild odor of alcoholic beverages emanating from his person. The defendant admitted to drinking one beer. Standardized blood sobriety tests were conducted, and the law enforcement officer observed 6 out of 6 on the HGN test, 3 out of 4 on the one-leg stand, and 3 out of 8 on walk and turn. The defendant consented to a breath specimen and blew .078 and .074. Law enforcement officers also found a loaded handgun in the center console of the vehicle.
Okay. Any prior DWIs?
No, Your Honor.
You've run his NCIC?
Yes, Your Honor.
Driver's license?
Still.
Please.
Sorry.
Mr. Gutierrez, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will revoke your bond, put you in jail. No more PR bonds. Do you understand? As long as you have a valid license and liability insurance in your name, then you may continue to drive. If you don't have either, then you're not allowed to drive, and that is also a condition of your bond.
Okay.
Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with Mr. Davila, and he'll tell you if and when you have to come back to court. If he tells me he can't get a hold of you because you're playing games or you're ducking and dodging phone calls, I will issue a warrant for your arrest. Don't pick up any new cases. I'll have you go to Victoria Center Reset. You'll get with Fleischer for your bond conditions, and then you're free to go.
Thank you.
All right.
All right, Judge, how's June 3rd or the 5th?
You hear that, Ray?
June 5th, please.
Okay.
Okay, man. Have fun.
Thank you, guys. Bye-bye.
Take care. You are Mr. Scott Sanders. Mr. Sanders, you're charged with criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On March 25th, 2025, officers initiated a subject stop at a Walgreens on East Mount Houston Road, Harris County, Texas. Officers observed a defendant sitting outside of the entry holding a brown cardboard sign, panhandling. Officers approached the defendant. Defendant stated, "Okay, I'm leaving. I'm leaving. They told me to leave. I'm leaving. Don't take me to jail." Officers asked consent to pat down the defendant. The defendant consented to the pat down. The officers observed a green leafy substance in a plastic bag located on the defendant's person. Defendant stated he forgot the marijuana was there, but that it was only kush. Officers observed an additional plastic bag containing a green leafy substance. The officers observed the marijuana to weigh 0.045 ounces. The complaining witness was identified by their Texas driver's license and advised that the defendant has shoplifted multiple times and has been trespassed. Complaining witness informed the officers that complaining witness asked the defendant to leave prior to the officer's arrival. Complaining witness advised officers the defendant initially left the property. Complaining was unaware of the defendant's return to the store until the officers contacted him outside the store. Officers note defendant's theft case was against that Walgreens and was dismissed. Officer notes that the defendant has been criminally trespassed from the same Walgreens. Officers also noted that they did observe a meth or crack pipe on the defendant's person. The complainant was able to identify the defendant based on the previous mugshot.
Mr. Sanders, I'm going to find that there's sufficient probable cause to go forward with your case.
Yes,
Let me provide you a lawyer today so that you can talk to someone about this case. All right. For now, do not go back to this Walgreens. Let's not talk about this case because you have the right to remain silent. I don't want you to say something that hurts your case.
I want to say something about seeking treatment.
Okay. Let me get you a lawyer first and then we can talk about it. We'll try to help you as much as we can. Okay. Vic, do you mind?
Please, Judge.
Okay. I'm going to have you sign a receipt, Victoria, and then we'll have you take your seat in the jury box, sir. Okay.
Right this way. Go ahead and sign for your step, please. Next judge is page 32, Williams. Come on up.
Good morning, Mr. Williams. Sir, you're charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 25th, 2025, an officer was dispatched to Montrose Boulevard for a call for service related to driving while intoxicated. The officers observed the defendant's motor vehicle upon arrival. The officers observed the defendant's vehicle to have major front end damage, multiple airbags reported, and to be leaking fluid. The officer met with the witness who called 911. The witness stated he observed the defendant's vehicle to have struck a light pole. The witness stated that he did not see the actual crash, but saw the defendant back up and start driving away from the crash. The witness observed the defendant drive several hundred feet before stopping due to the motor vehicle being disabled. The witness stated that they observed, the officer made contact with the defendant, and the officer observed strong odor of alcoholic beverages emitting from the defendant's person. The officer also observed the defendant had bloodshot eyes and slurred speech. The officer observed the defendant had trouble maintaining balance as well. The defendant consented to standardized field sobriety test. The officer observed 6 out of 6 clues on the HGN test, 7 out of 8 on the walk and turn, and 4 out of 4 on the one leg stand. Defendant consented to a breath sample, and which the test readings came back at 0.185 and 0.168.
Any prior DWIs? And then does he have a license?
No prior DWIs, Your Honor, and I'm running that license.
Please. Mr. Williams, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will revoke your bond and put you in jail.
His license is eligible. No.
As long as you have a valid license and liability insurance in your name, then you may continue to drive. But if I find that you're using, it's not going to go well, and I will revoke your bond and put you in jail. Do you understand? Do you have the ability to hire a lawyer, sir? Okay, we will give you time to hire a lawyer. So I will first have you go to Victoria, sign a reset. You will then get with Fleischer for your bond conditions. After that, we'll get you out here to hire a lawyer. All right? Please.
This way.
Good morning, Ms. Woods. Ma'am, you are charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
On March 26, 2025, in Harris County, Texas, officer was dispatched to a disturbance call. Officer met with the complaining witness who stated that he and the defendant were in a sexual relationship. Complainant witness stated that he and the defendant got into an argument over the Wi-Fi password. The defendant punched the complainant witness in the face, head, causing pain. The defendant also ripped the complainant witness's shirt, scratching him in the process, also causing pain. Officer DeVert observed the defendant to have visible injuries to his face and back.
Do we know whether he wants to have contact?
No, it's not.
He does not want
He
to.
does not.
Okay. Ms. Woods, I'm going to find that there's sufficient probable cause to go forward with the case. A protective order has been issued in this case. I would get to know it. If you do something to violate the protective order, the state can and probably will file a violation of protective order against you. It's one of the worst cases you can pick up. I am warning you now as a condition of your bond not to have any contact with this person and not to be in possession of weapons. If you violate this, we will revoke your bond and put you in jail. Do you understand me? You have the ability to hire a lawyer. We can have you fill out an application. I'll take a look to see whether you qualify. Deputy Miranda is going to give you an application. I need to know everything about you, where you work, what kind of money you make, money in the bank, car, what kind of car you drive. And then I'll take a look to see whether you qualify. I'll have you sign a receipt with Victoria. We'll give you the application, then we'll have you take a seat in the jury box. Thanks.
This way.
And they're dismissing the felony upstairs, and he's
Change for
doing,
this?
yes, for the probation with TRAS conditions.
Has a TRAS been done yet?
Yes, and your recommended IOP is
Solicitor.
No, shh. You have, or you're not you, but your lawyers have worked a killer deal for you today. You speak English, right?
Yes, I do.
Where they're going to dismiss the felony in exchange for your plea on this case. I'm going to tell you now, this is not something that happens very often. So get a clue. Do you understand?
Yes.
The agreement that you have worked out here is you're now charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. The agreement that you have is 180 days in jail to be probated for 15 months. You need to understand that this charge is going to go on your record. It will be there for the rest of your life. From now on, you're facing a minimum of 30 days in jail for any new cases that you pick up. Not only that, whenever you get pulled over, officers, the first thing they do, and the only thing they do when you get pulled over is they look at your record. If they see that you have a prior DWI, if they see that you have a prior felony PCS, you think they're going to treat you good if they smell anything funky? Probably not. So don't give them the ammo to shoot you with a gun. It is a DW, any prior DWIs? So the agreement is a DWI education class, one victim impact panel, a TRAS, but you have already done it. So the TRAS here is recommending intensive outpatient treatment followed by supportive outpatient treatment. This is what you must do. If you fail to complete these conditions, I will issue a warrant for your arrest. I will put you in jail and I'm going to bring you right back out in orange, and we're going to talk about whether you violated, and if you did, if you do, you're looking at 180 days in jail. Do you understand? No drugs, alcohol, random testing, and a guardian in a lock.
He has, we're gonna do the portable because he's not driving, doesn't have a license.
You'll be signing an affidavit today promising us you're not going to drive. Mr. Garcia, do not drive. If you want to see me grow horns and a tail, I'm telling you, don't drive. If you want to drive, do things the right way, ask for permission, get a license, get insurance, and then I will be dancing happily because you're doing things the right way. But if you go out and you do it on your own and you're not licensed, I'm going to lose it. You understand? All right. You're giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. How do you plead to this offense? Guilty or not guilty? I'm going to find you guilty. I will send it to you this agreement. Good luck to you, sir.
Thank you very much, Judge.